What legal agreements must US companies modify for Canadian law? Expanding into Canada is not just about registrations and tax accounts. Your legal paperwork has to cross the border too. Contracts that work fine in the United States can fail quietly in Canada, either because the law is different or because the terms do not map cleanly to Canadian rules. The trick is not to rewrite everything from scratch, but to identify the agreements that interact directly with Canadian customers, staff, data, and courts. Those are the ones that usually need a Canadian tune-up. Customer and service agreements. Your customer contracts are often the first documents that need attention. Clauses that choose the law of a particular US state and the exclusive jurisdiction of its courts may not be realistic once you are dealing with Canadian clients. Many Canadian businesses expect Canadian governing law, especially when services are performed in their province. You also need to adapt tax language. Invoices to Canadian customers will often include GST, HST, or provincial sales tax, and contracts should outline who is responsible for collecting and remitting those taxes. Currency clauses matter as well. Stating prices in US dollars with no reference to Canadian tax or exchange rates can create surprises for both sides. It is also common to review limitation of liability, warranty, and indemnity provisions in light of Canadian consumer and business standards. What is enforceable in one US state is not automatically enforceable in a Canadian province. Employment agreements and contractor documents. If you are hiring staff in Canada, US employment templates usually do not fit. Canadian employment law leans more heavily on statutory minimums for notice, severance, vacation, and benefits, and courts are more protective of employees in areas like termination and non-competition clauses. Employment agreements should reference the correct provincial employment standards legislation, spell out benefits and vacation in a way that matches those standards, and handle post-employment restrictions in a manner that Canadian courts are likely to accept. The same goes for independent contractor agreements, which must be carefully drafted to reflect genuine contractor status under Canadian tests rather than simply using the label. Ignoring these adjustments can lead to unexpected liabilities if relationships sour or if regulators take an interest. Distribution, reseller, and agency agreements. If your Canadian go-to-market strategy relies on distributors, resellers, or agents, their agreements need to fit the Canadian context. That usually means reviewing territorial clauses, exclusivity, intellectual property language, and termination rights under Canadian competition and contract law. You also need to decide how risk and responsibility are split between you and your Canadian partners on issues like returns, product safety, and regulatory compliance. Canadian courts will look at the actual relationship, not just the contract labels, so clear, well-adapted terms make your intentions easier to uphold. Website terms, privacy policies, and data agreements. Any online service touching Canadian users has to align with Canadian privacy expectations, particularly consent, transparency, and cross-border transfers. That does not necessarily mean you need a separate Canadian privacy policy, but your existing policy and website terms of use should be reviewed against Canadian privacy and consumer protection rules. If you are transferring customer or employee information from Canada to the United States for processing, contracts with service providers should address security standards and responsibilities in case of breaches. Large enterprise customers will often ask for privacy and data processing terms that reflect Canadian law explicitly, so having a ready Canadian-aware version avoids scrambling later. Leases and real estate agreements. The moment you lease office or warehouse space in Canada, you step into provincial landlord-tenant law and local commercial real estate practices. Standard US lease forms often assume different default rules around repairs, insurance, and remedies. In most cases, your landlord will provide a Canadian lease form, and your job is to understand which clauses interact badly with your US assumptions. Where you are the landlord, you will need to rely on Canadian templates tailored to the province where the property is located. Cross-border intercompany agreements. Once you have both a US parent and a Canadian subsidiary, intercompany agreements become important. These include management service agreements, intellectual property licenses, cost-sharing arrangements, and transfer pricing documentation. They need to be enforceable in both countries and priced on an arm's-length basis. You are not just drafting for commercial clarity here, you are drafting for tax authorities on both sides who will scrutinize how profits are split. That is one area where borrowing a generic US template is particularly risky. Final thoughts. Not every document in your US template library needs a Canadian version, but the agreements that touch Canadian customers, employees, data, and real estate almost always do. The goal is to preserve your business model while swapping in Canadian-friendly governing law, regulatory references, and practical terms. If you want a more concrete checklist of which agreements to prioritize and what to tweak first, you can visit our website, where we walk through the contract types that usually move to the front of the line in a Canadian expansion. If you require assistance with Canadian tax matters, our team is ready to provide reliable professional support. Please contact us at 416-283-8774 or visit theaccountingandtax.com for more information. And if you found this video helpful, don't forget to like, subscribe, and share.